And I have 4 o'clock.
Very good.
All right, so we're going to call to order the Board of Zoning Appeals meeting for February 18th, 2021. And we will do a roll call.
Margie or Dean, do you have the roll call or do you want me to do it?
I think Dean's trying to get unmuted.
Okay. I've tried to unmute him on my end.
Looks like I'm now unmuted, so I'm going to call roll. And I'm call Board Member Miles.
Madison, you'll want to unmute the little unmute button at the bottom left of your screen usually.
Hey, can you hear me now?
Yep. So we're calling roll.
Yes.
All right.
Board Member Miles, are you present?
Here? Yep.
Board Member Dorsweiler?
Here.
Board Member Sharp? You need to be unmuted.
Well, I think he hopped
Looks like
out and
he
now
might
he's
have
hopping back
left.
in. He's trying to hop back in. Must be having internet issues again.
I see him again. Board Member Sharp, is he present? Board Member Rada?
Present.
Board Member Olson?
Here.
So we have a quorum of 5 members today. Margie, can you confirm that the Kansas Open Meeting Act has been met for today's meeting?
Yes, I can confirm the packet was posted and the notice was provided.
Okay.
We can move ahead with today's meeting.
Well, can we do approval of minutes for the January 21st, 2021 meeting first?
Yes.
I'll move that we approve the minutes from our last meeting. This is Dortzweiler.
I second that.
Okay, so it has been moved and seconded. Can
Who
we
was the
get
second? Who was the second on that?
Richard?
I'll second that. Rada?
So all those in favor of approving the minutes from the January 21 meeting, Board Member Miles,
Aye.
Board Member Sharp,
Aye.
Board Member Dorsweiler,
Aye.
Board Member Rada,
Aye.
Board Member Olson.
Aye.
So the minutes are approved 5-0, which moves us to new business.
Okay, which takes us to public hearing item application V20-9, and is the applicant present?
Mr. Jerry Frank is present, and he's going to represent the applicant, in this case, Mr. Bill Swinson.
We're both here.
Okay.
Bill and I.
Okay. So presentation by staff.
Okay, for the benefit of staff, or the benefit of board members, staff had recommended continuing this item to today's meeting to allow a representation for the applicant to be present at the hearing. And the area we're looking at is called Tenlawns Court Addition. It dates back to 1939, and it's a very small plat that contains 10 lots facing Tenlawns Place. And the lots are relatively small by Salina standards. They're on the west side of the street. They're 50 feet wide and 100 feet deep. And the ones on the west side are double frontage, which means that they have frontage on both Tenlawns Place and Sherman Street. Our records show that the homes on this block were built in the early 1940s. And somewhat unique, instead of having the standard block numbers, such as the 800 block south of Crawford. These lots are addressed individually 1 through 10, and the subject of this application is number 7, which Dustin had up there, that showed the request area. So the lot we're talking about is a double frontage lot, and it measures 50 by 100. And the existing improvements are a dwelling that's 32 by 32 feet, and then there's a 12 by 18 detached garage in the southwest corner of the lot. The existing dwelling is set back 20 feet from Tenlawns, and the existing garage has a non-conforming setback of 16 feet from Sherman Street. Based on their age, both of these structures are grandfathered in. The city's residential building inspector observed the applicant constructing an addition onto the rear of the garage and determined that he had not obtained a building permit for doing the work. So a notice was sent to the owner applicant for doing work without a permit. One of the remedies for doing work without a permit is to apply for a permit, which allows us to permit the work and perform inspections. Those permit plans were submitted, and the city zoning administrator determined that it was not a freestanding shed, but was an addition to the existing detached garage. So there's two things at play here. Not a meeting of the minds on the fact that when you attach a shed to an existing structure, it is considered an addition and not a freestanding shed. So if you put up a shed that is less than 120 square feet, you do not need to obtain a building permit for that. But if you attach that shed to the garage, then that becomes an addition, not a shed. So the other thing is that the property owner is of the belief that his property lines start at the curb line of Sherman Street. And so all the measurements were taken from the curb line, not the property line. So the options were to relocate the shed elsewhere in the yard and make it a freestanding shed, or apply to the Board of Zoning Appeals for a building setback variance. So this is coming before you for a request for a setback variance from Sherman Street. And so we had a public hearing scheduled for this on the 21st of January. And so we have carried it over to today's meeting because no action was taken on the 21st of January. So the standard setback from a residential street is 25 feet. A lot that has double frontage has 2 front yards, 2 side yards, and no rear yard. And a freestanding storage shed would be considered to be a freestanding accessory structure, but in this case, it's attached to the garage, which means that it should have a setback that would be applicable to a garage. So in order to be separate, it has to be located at least 3 feet away from the garage. So what we're discussing is that the owner is correct. If you put up a shed of this size, you don't need a building permit, but if our interpretation is it's attached to the garage, and that makes it not a freestanding shed. The other point is that the 16-foot setback for the garage is grandfathered in, but this extends another 12 feet into the Sherman Street front yard. So in terms of the conditions that are unique, the applicant states he built the shed believing he did not need a building permit because it was 120 square feet in size. And he notes that he has double frontage, which reduces his usable backyard. As I noted, we agree that you don't need a permit to put up a shed 120 square feet or less. However, you still have to conform with setback requirements even if you don't get a permit. And this does make for challenging enforcement situations for staff. And so one of the things the building permit review process does is allow staff to inform homeowners where their sheds can and cannot be located. We agree that the lot is unique. It has 2 front yards, 2 front yard setbacks, and it's compounded by the fact that it's only 100 feet deep, which is shallower than most lots in the surrounding area and in the community, and this really limits the applicant's usable area behind his house. One thing we did look at, and Dustin is kind of showing on the aerial photo, is that we looked at all the garages that back up to Sherman, and there's kind of a prevailing setback line there that we determined to be 15 feet. So all of those are pretty much lined up on a 15-foot line. So that's the prevailing setback, but this addition extends 12 feet into that setback area. So as far as impact on neighbors, the applicant states that the storage shed is located behind his garage on his own property. Because of the double frontage nature of this lot and the fact there's no privacy fence or anything, the real impacted properties are the lots on the west side of Sherman, which are looking out their front doors at this shed. The property to the north actually does have a privacy fence, but it encroaches slightly into the right of way, and the applicant does not have a rear privacy fence, which makes this shed more prominent and visible. So I don't know, Dustin, have you shown photographs of that from the street? And so the garage to the south is on a neighboring lot, so you can see how this sticks out from the building line of that garage. The applicant points out that the shed is already built and would cost a great deal of money to move or remove. And staff would agree that if we strictly applied the 25-foot setback, that would eliminate most locations from the applicant's lot. However, we determined that the prevailing setback on Sherman is 15 feet. So we can't speak to the direct cost involved, but staff does believe that there's locations in the north or in the northwest corner or towards the northwest corner of the applicant's yard where a shed could be placed and conform with the 15-foot setback requirement as a freestanding shed. If that were done, as long as it lined up with the back wall of the garage, a building permit would not be needed and there wouldn't be a need for a setback variance. The applicant states that in this neighborhood, there are many houses and structures located closer to the road than his shed. We're showing you the entire block here between Frost and Brown and the buildings that face Sherman, and we're not sure that we agree that there are structures located closer to the road than his shed. So we're not sure what structures he's referring to. What we're pointing out is that the garage is non-conforming, but Mr. Swenson has increased the non-conformity by adding on to the rear. There's no driveways or anything in the vicinity, so the location of the shed doesn't impact the public because it's not affecting visibility or blocking driveways or street visibility. The one thing we wanted to point out was that the applicant seems to have been mistaken about where his property line is. He believes the setbacks measured from the edge of the street, and Sherman Street is a standard residential street, so it has 60 feet of right of way and 33 feet of paving. This means that there's about 13.5 feet of public right of way behind the curb line before you get to the property line. And this is something that is somewhat common, that a lot of property owners have the belief that their property ownership goes all the way out to the curb line. We did not require a survey in this circumstance, but we're confident that a survey would show that the property line of Mr. Swenson's lot's about 13.5 feet east of the curb line. And so by our measurements, the shed's only 4 feet away from the property line. So what we're discussing here is that an accessory building is permitted on a residential lot. Mr. Swenson is permitted to have a detached garage and he's permitted to have a storage shed. The question is where the shed can be located. So on a conventional lot, a shed has to be 5 feet from the rear property line. Mr. Swenson perceives Sherman Street to be his backyard and doesn't believe that putting it behind the garage is opposed to the spirit and intent of the ordinance. One thing we wanted to point out for the board that we have that relates to fences that does not relate to sheds, but possibly could, and that is when you have a double frontage lot, since there's lots out that back up to Schilling Road, there's some lots east of Ohio on the south side of Magnolia Road where lots back up to Magnolia Road. And in those situations, the zoning ordinance allows the property owner to designate one of the yards as a rear yard, and that allows a solid fence to be erected. We don't allow solid fences to be erected between the front door of a house and the street. But that same language is not in the ordinance that deals with accessory structures, and so it's a little more ambiguous. And as we point out, the city has been fairly inconsistent in enforcing the building setback on double frontage lots, particularly for storage sheds less than 120 square feet that didn't require a permit. If you drive down Schilling Road between Ohio and South 9th Street, you'll see a number of small storage sheds located in the areas along Schilling Road. And most of those are behind privacy fences, so they're a little less visible, but nonetheless, those are technically in a front yard. So there is some inconsistency on the city's part in that matter. On the other hand, as staff looked at this, there's a fairly simple solution that would not require approval of a setback variance or the issuance of a building permit, and that would be to relocate the shed to the northwest corner of the lot, line it up with the rear of the shed with the rear wall of the garage, and that would be a code compliant solution. I think the question before the board is whether leaving the shed in its current location would have a negative impact on neighboring property owners or set an unfavorable precedent. I don't think you'd be setting an unfavorable precedent because the city has, as I noted, been inconsistent on its enforcement of sheds on double frontage lots. And as to the impact on neighbors, hopefully board members received by email a copy of some statements that were submitted by neighboring property owners that they don't find the shed as it's located objectionable. So what I wanted to do before I talked about your options, we have Jerry Hammerton, who is our residential building inspector. And what we would be interested to hear from him, and if Dustin, if you could put up a photograph of the shed. Could Mr. Hammerton outline the things that if there was a variance approved for this shed, are there still things that the owner needs to do in order to finalize getting a building permit for this shed? So we think it's important for the board, for the applicant to hear from Mr. Hammerton what things might still need to be done to the shed if a variance were approved?
Well, I went out there yesterday and took a look at it with Jerry Frank and Bill, and I didn't really see anything that he needs to do additionally other than he needs to paint it so he's compatible with the colors. But he has a foundation. It looks like it's on skids. He used like a skid type floor, but it's sitting on piers. And he stated that they're 3 feet deep, which meets our code. And I looked at the framing and the way he attached it to the existing garage, and it all meets our building codes. So he really wouldn't have to change anything structurally for it.
So what we didn't want to see happen would be have the board vote to approve a variance and then staff still be unable to issue the requested building permit. So it sounds like from Mr. Hamilton's perspective that it's strictly a matter of the location and the variance request. So your options this afternoon would be to approve the requested front yard setback variance on Sherman to allow the shed to remain in its present location. You could postpone consideration of this request until the applicant obtains a survey of his property. I think that would only be relevant if we were going to be in a great dispute about how far it actually is from the property line. You could postpone consideration of this request if you find that additional information from the applicant or staff is needed to make a decision. You could deny the applicant's variance request if findings in support of a variance cannot be made, and direct the applicant to relocate the shed. So staff would be open to any questions that we have. We think that the lot has unique characteristics because of its 100-foot depth and the fact that it's got 2 front yards. That is definitely unique. It's less than ideal that we're sitting here talking about a building that's already up, but that shouldn't take away from the considerations of uniqueness, hardship, and other considerations. And as I noted, the city's been pretty inconsistent on enforcement of setbacks on double frontage lots. And the fact of the matter is, if you have a backyard, what you perceive as a backyard shed, and it's behind a privacy fence, it's a lot less noticeable than a situation like this where there is no privacy fence and the shed as constructed is quite visible from Sherman Street. So with that, I'll pause for any questions the board might have for myself or Mr. Hamilton. And if not, we would hear from the applicant or their representative, and hopefully board members received the written comments from neighbors that we sent out this afternoon.
Any comments for staff from the board?
This is Dortzweiler. I was just curious, is the shed actually attached to the existing garage, or is this a prefab shed that was just kind of pushed up against the existing garage?
I think Mr. Hamilton is the best person to answer that question.
Yeah, it's actually, he built the addition and it's attached to the existing garage. It even has an opening so you can access it so that it's like all one building. That answer that?
Yes, it did. Thank you.
Okay.
So was it a prefab shed that was then attached, or was it actually built?
Well, I'm under the impression it was actually built. You might have to ask Bill that question.
You want to tell him? Was it you stop? Bill?
Any other questions for staff from the board?
The escalator problem.
Okay. Comments from the applicant then?
I'm Jerry Frank, just a neighbor. I want to thank you all for your time and for looking into this. It's, it's just one of those things that probably shouldn't have happened, but it did. So now what do we do? I saw Bill working on it, and then he stopped working. I was wondering what was happening. In fact, we stopped and asked him one time if he's okay. And then the letter came letter from the city explaining the request for the variance and stuff. And that's where I became involved. I asked if I could help him out a little bit. So I'm just a neighbor. There was one picture we had of one aerial view of Hanson Hollow, the street right to the south, if we could get that pulled up. And you can see there were quite a few of the, yeah, that's not it. Yeah, you can see there were quite a few of those garages are just about backed up clear to Hanson Hollow, the street, with a whole lot less from the street, from the curb to the building than what Bill's even asking for. So it's just showing that the precedent's already been here in the neighborhood. Other than that, I think Dean said it pretty good. The letter, I took a letter down to the people on Sherman. I live right on Sherman, 7-6, right on the corner of Sherman and Venango. And the people all signed it. They were all hoping he could get it, that the variance be granted. In fact, another person happened to see that paper. Mine's the other one. But somebody saw it. He's got a big 2-car garage, detached garage on his, a Morton type building. He had said, nobody gets a big enough garage. And so the simple fact that the garage is pretty small, and then he's adding this part on the garage. If you would move it, you'd lose that detached. You lose that attached part. There's no question it's attached to it. There's a doorway cut between them. I think it'd be a good thing to have. If I was living there, I'd like it. So I don't know if there's anything else we can say about that. Do you have anything you wanted to say, Bill? I don't know if anybody has any questions for us.
So kind of back to my question originally. So was this a prefab shed that you purchased and then attached, or did you actually build this directly onto the back of the existing?
He actually built it on, it's a stick built. He built it off from just wherever he got the lumber and then, cut each piece and put it together on it. The reason it's not painted or finished now is because once all this started, then he quit working on it, and he'll finish it up this spring.
Okay. Any other questions for the applicant from the board? Okay. Comments from any other interested citizens? Dustin, do we have anybody else that's on?
I'm looking to see if anybody's interested in commenting, and I don't see anybody.
So the board should have had within their packets, there was a letter from Jerry and Greta Frank, who live on Sherman, and then Margie sent out, maybe it was this morning, right before noon, the thing that Dustin had put up, which was an expression of sentiments of neighboring property owners. So I would assume that those owners would let these written signatures speak for themselves in lieu of joining the meeting. But we did send out notification letters on this case, and what we've received back from neighboring property owners has been mostly positive, and I don't think that I've received anything from a neighboring owner that was negative towards what Mr. Swenson has done.
Now, just to make sure we're on the same page, I got those signatures from the people occupying the house. A few of them are rental property, so it wouldn't be it wouldn't be the actual owner, it would be the renter that signed it. I don't know all the landlord, all the owners. So
Okay. So, any other questions from the board to either staff or the applicant? If not, we're going to close comments from interested citizens since we don't have any and take it back to discussion of the board. Any comments? I guess for me at this point, since it is pretty much built, I understand that he should have had the building permit initially before he got started with it, with the double frontage lot, and then actually looking at the properties to the next blocks to the south, as close as they are to the property lines. And again, even what we've done on Shelling Road, I guess I would be in favor of allowing this variance without having to make him relocate the structure.
Yeah, I would agree with that. I think as, you know, you look at the property, even in the future, you know, if future sale of the house, it's just going to improve the value of it. And if he will agree to paint it and it matches the existing structure, I don't see where there's any problem in that.
This is Dortzweiler. I'm not necessarily a fan of building it and then begging for forgiveness. However, given the fact that the neighbors in the area apparently do not have an issue with it, and all of the hard hand-built work that he put into building the shed, I guess I necessarily don't believe that I would be opposed to allowing the variance.
Okay. Do we have a motion?
Yeah, I'll make a motion that we approve application V20-9 with, I would say stipulation that it gets painted and it matches the existing structure.
I'll second that. That's Dortzweiler.
Okay. So we have a motion and a second. Can we do a roll call?
All those in favor of approving variance application V20-9 per the motion, Board Member Rada,
Aye.
Board Member Miles,
Aye.
Board Member Olson,
Aye.
Board Member Dorsweiler,
Aye.
Board Member Sharp.
Aye.
Okay, for that motion passes 5-0 with the stipulation that the wall be painted to match. Do you have any questions, Mr. Frank or Mr. Swenson? We will, what we do is we take today's action, we will put that into a letter, and we will send that to Mr. Swenson. And the building permit for the shed will be attached to that letter. And obviously, we'll give Mr. Hamilton a copy as well, but we'll inform our permit tech that the permit that was applied for can be issued, and we'll have a written record of today's meeting that will be provided to Mr. Swenson. Would you like to be copied in on that, Jerry, just so you know?
No, I'm fine. I appreciate what you guys have done. It was kind of a side, and thanks for all you've done. You worked, you know, we didn't used to get along. I'm a contractor. We didn't used to get along with the zoning, with the permit department like we do now. So that's a good step in the right direction. When I took the petition down to the neighbors and I explained them what was going on, and almost every one of them said, "What's the city doing now?" And I said, "No, the city's working with us on this one." I said, it shouldn't have been built. And it was just kind of fun for me as a contractor to be able to say the city's working with us instead of, yeah, they're doing it again. So I thank you all for that.
We appreciate it.
All right, we appreciate you being a good neighbor, Jerry.
Well, you're sure welcome. Thank you, guys. I'll sign off.
Thank you. All right, so that moves us to public hearing item application V21-1. Is the applicant present?
No one?
Okay.
Looks like they are present. Dustin?
Yes, it does.
Okay. So on item 3.2 is application V21-1. It's been filed by Sergio Carina Chihuahua, and they're requesting a front yard setback variance of 2 feet from 17 feet, which is the minimum setback that needs to be maintained for a covered front porch, to 15 feet. And that is to allow a covered front porch to extend out 10 feet into the front yard setback area. So the property in question is located in the Cloud Addition, north of West Cloud Street at 1610 Hickory Street. So we have provided you with information in the packet about the Cloud Addition, which dates back to 1955. And the dwelling on this particular lot was constructed in 1957. Platted lot 27 is 73 feet wide, but the applicant's lot is only 69 feet wide. It's the south 69 feet of that. The original house is 24 foot by 40 foot, has an attached carport on the north side, and as constructed, the house is set back 25 feet from Hickory Street, which is the minimum front yard dwelling setback in the R1 district. In the fall of 2020, the Building Services Division observed that a covered front porch had been constructed at this address and that no building permit had been applied for or issued for the new construction. A notice was sent to the property owner for performing work without a permit. The owner applied for a building permit for the covered porch addition. Myself, the zoning administrator, determined that a permit could not be issued for the covered porch because it extended 10 feet into the front yard setback area, and a porch can only extend out 8 feet from the front of a house. So the options were to modify the porch or remove it or apply to the Board of Zoning Appeals for a front yard setback variance to allow the 10-foot porch. This application was filed on January 8th and scheduled for a hearing today. So as we noted, you have an existing house with a 25-foot setback. That application was for a construction of a 10-foot by 20-foot covered front porch at 10 feet. That extends 10 feet into the front setback area on Hickory. And the applicant is requesting that the Board of Zoning Appeals approve a front yard setback variance that would allow the front porch to be completed and remain in its current location and configuration. As justification for the requested variance, the applicant states that the covered porch will help the handicapped residents of the house. So we've cited for you on page 2 of the report, there's an exception to the 25-foot setback requirement. That exception says that extending out into the front yard will not be considered an obstruction if it's an open, unenclosed porch projecting 8 feet or less into the front yard. Well, in this case, because the house is set back at 25 feet, the 10-foot porch extends 10 feet. And so the zoning administrator does not have the authority to approve a permit for a 10-foot porch that extends beyond that setback line. So just as with the previous case, the application for a building permit and submittal of plans is the means by which staff is able to communicate to property owners about building codes and the limitations of what they can put on their property. When they don't apply for building permits, it's difficult for staff to convey that information to the property owner. As far as the uniqueness, the applicant states that 2 handicapped people live in the home and would like the covered porch to line up with the sidewalk. So I think you can see in this photograph here, there's a set of steps that come down that lead to a sidewalk that connect over to the driveway. And so indication is that the porch is as it is so that it would line up with the sidewalk that connects to the driveway. As we have looked at this, we haven't really been able to find any unique physical conditions that relate specific to this lot that are not shared by other lots on Hickory Street. The house is relatively small. The lot is pretty much standard size for the neighborhood. The original construction lines up with the other homes on Hickory. And so this is really a question about the need for a 10-foot porch versus an 8-foot porch. And the applicant indicates that it's a nice added feature to the house and a neighborhood improvement. They don't believe the 10-foot width will be noticeable to the neighborhood or have a negative impact on neighboring properties. I think we'd agree that it's difficult to necessarily to the naked eye to identify the incremental increase between 8 feet and 10 feet. I think this came of notice because it went from having no porch to having a fairly substantial porch and no record of us having reviewed or issued a permit. I think attached to your packet, there's a number of letters of support from neighboring property owners and residents, which are attached in the packet. And these letters indicate that the neighbors do not see the covered porch as having an adverse effect on the neighborhood. So again, we want to point out that we are here this afternoon not because there's a covered porch there, but the question of how much of a front yard a covered porch can occupy. We are certainly supportive of property owners making investments and making improvements to their property. We, as a staff, believe that it's best accomplished through the building permit process. That helps ensure that improvements are built safely and properly, and that helps preserve and protect property values and public safety. And so while a 10-foot porch may be perceived as not harming the neighborhood, planning staff did not have an opportunity to review the plans for this porch until after it was built. The applicant believes it would be a financial hardship to remove the improvements they've made. And the applicant has indicated that the two handicapped residents need the covered porch and exit. And so again, this isn't a question about whether the property can have a porch or should have a porch. It's a question of how far it should be allowed to extend into the front yard. The applicant has tied the need for the 10 by 20 porch to the need to improve handicapped accessibility at this residence. However, in discussing this with the building official, 8 feet is more than adequate to allow for handicapped accessibility. And I guess the question staff would have is that the porch has stairs and not a ramp. So we're not able to see from our perspective how this construction improves the handicapped accessibility to the dwelling. And we would note that if there is a financial hardship associated, if a building permit had been applied for to build this, we would have an opportunity to turn it down and explain why. So from at least one perspective, the hardship experienced by the applicant is to a degree self-created because staff was not able to inform them of what the limits on size of front porches are. The applicant states that the overhang only hangs slightly into the front yard area and any impacts would be local and not impact the general public. We would certainly agree that this has minimal impact on the general public. The only thing that relates to public health and safety is because a building permit was not obtained, it's not clear whether the foundation and supports meet residential building code requirements. So again, we we've talked about why we have front yards. They preserve open space. They maintain visibility. The applicant points out that the porch will help handicapped residents of the house, but doesn't say exactly how this additional width benefits them. So again, our setback requirements, the purpose is to preserve adequate open space adjacent to public streets. It maintains sight lines for pedestrians and traffic and adjacent public sidewalks. Having a uniform build-to line also maintains visual appeal in neighborhoods. A variance to allow an additional building encroachment should only be considered when the physical characteristics of the lot make that the only feasible option for expansion or new construction. So it's not staff's desire that the applications we bring to you be for post-construction after the fact variances. Whether the property owner should have known that a building permit was required in this case is a judgment for board members to make. Because of the circumstances here, it's important that the board make clear findings to support their decision. And so again, as we looked at this, it's not a case of whether the dwelling at 1610 Hickory can have a covered front porch or whether it should be allowed. The issue is whether there's justification under these circumstances to allow that porch to be 10 foot by 20 foot instead of 8 foot by 20 foot. So we haven't really seen any relationship between the 10-foot width of the porch and benefits to handicapped accessibility. So we're open to hearing about that. And we're not seeing a lot of uniqueness of physical conditions on the property, but we would point out that you have the alternative today to approve the requested 2-foot front yard setback variance. You could postpone consideration of the application and direct the applicant to come back with additional information to demonstrate that there's no practical alternatives to the 10-foot dimensions of the porch, or you could deny the applicant's request. So we would ask the applicant to provide additional information about the relationship between the porch and the handicapped accessibility to the dwelling and why they were unaware a building permit was needed. If that information is provided to your satisfaction, then we think in this case, irrespective of the not obtaining a building permit, the board needs to balance what is the relative benefit gain to the neighborhood from achieving strict compliance when no neighbor objects to the porch, and weigh that against the financial hardship that would be associated with modifying it so it only extends 8 feet into the front yard. So again, this is it's not a question of whether the improvement can be there at all, it's whether there is justification in this case for the incremental increase from 8 feet to 10 feet in terms of extending out from the face of the house. I might, is Mr. Hamilton still with us, Dustin?
Yeah, I'm still here.
Is there anything that I'm missing as it relates the same question here? Should there be a setback variance approved? Are there outstanding items of information that you're lacking about this porch that would delay or prevent issuing a building permit if a variance were approved?
No, not really. Structurally, the buildings are built to code. In fact, they did a pretty good job on the framing of it. The only thing I would still need to verify is the depth of the footings for those posts. I don't recall if they were actually buried in the ground in a footing or if they're sitting on top. So I would need to verify that. And then, of course, they need to finish it.
at this time, we would, staff, including Mr. Hamilton, would stand for any questions that board members might have of us about this property or this project.
This is Dort Swiler. What are the penalties for failing to apply for a building permit?
Well, it depends on how far it goes. It can, if there's non-compliance and non-responsiveness, then it can go as far as municipal court. I have been involved with 2 cases where a municipal court judge ordered that an improvement be modified or removed, and then also imposed fines on the property owner. But that's at the far end of the spectrum. But the ultimate impact, if there's an impasse, is to refer a matter like this to municipal court, where it can be prosecuted, and then it's up to the judge of what penalties they might impose.
Also, was there a building contractor that was used to build this porch, or who built it?
I might refer that to Mr. Hamilton or perhaps the applicant and see if Jerry knows. Do you know who actually built this, Jerry?
I believe the applicant has a friend that's a contractor, and I think he's the one that's with him right now. I'm not sure. You have to ask them.
Hi, this is Jacob Wilson. I'm going to try to help Sergio here today, so he understands everything fully. He doesn't speak great English, so we're going to try to assist him here. I was not involved with the building of this structure. My company, Restore Construction, pretty frequently hires HDN Remodeling, which is who Sergio works for. And the owner of the company is named Hector Ortega. Sergio and Hector built the structure. They do really good work. That's why I'm here today, because I hire them quite a bit on our projects and use them on our projects. I think there was a previous question asked, how deep are the footings, and they're 32 inches deep in depth. From speaking with Sergio and Hector prior to this, the intent of the structure is for 2 handicapped residents of the home. It's actually Sergio's mother-in-law and sister-in-law. They're both in wheelchairs. They do plan to install a ramp where you see the temporary steps on the structure. So there is plans to install a ramp, and the decision of the 10-foot coming off the house was mainly for an aesthetics decision to line up with the sidewalk for where the ramp would go. So that's all my knowledge of this, but I'm going to try to help Sergio here today. And this is Sergio here. Get through this, because like I said, his English is not 100%, and I want to make sure that he understands everything clearly.
So the Hector has what construction company?
It's HDN Remodeling.
Okay, so is that a licensed contractor in Salina?
He does subcontract work. He generally doesn't fall. He's not a general contractor.
Not a general contractor, but is he a licensed contractor in Salina? So this question would be back to staff.
We'd have to check our, we have in Salina, there's what Mr. Wilson's referring to is we have Class A contractors, we have Class B contractors, and then we have specialty contractors and subs, which fall under Class C. And we have some who are registered only and some who are licensed. And you have to be licensed to do a Class A general contractor. You don't, in some of the general trades, you don't have to be licensed. You only have to be registered. But we don't have, I don't think we have access to our license and registration list. We can access it during this meeting, but it's entirely possible that someone can be a tradesman and not be considered a licensed contractor. We have painters, we have roofers, we have carpet installers, we have people like that that are contractors, but they're not licensed because they're not considered general contractors. But we'd have to check to see if HDN falls under one of those categories.
And the reason for my question is whether they're a registered or a licensed contractor. At some point, then they should know that you would need a building code in order to put this structure up. So somebody that would be registered should know that they would have needed a building permit.
I don't believe they have a license in Salina.
Okay.
Generally on our projects, they do drywall and framing type stuff for us.
Okay.
You know, I think Sergio just set out to thinking he was doing something nice for his sister-in-law and mother-in-law and not understand the process. He does understand it now after all this has come about, and he has stopped working on the structure, but would like to continue. And I mean, I have full confidence in him that he would finish it, and it would be a really nice end product.
So does Sergio actually live at this property then?
Yes.
Okay. And for the building inspector, so what is the depth that would be needed for the footings on this type of structure?
Be 36 inches below grade, below finished grade.
Okay. And sorry, the gentleman helping Sergio, you said they were 32 inches, so it doesn't meet code?
That's correct. 32 inches is what I was told.
Okay. So at that point, it wouldn't meet code for the building permit if he'd applied for the permit. Is that correct?
That's correct.
Okay. So
This is Dortzweiler. I think it's also important to point out that there's really nothing unique about the property that would warrant a 2-foot variance at this from what we've heard so far. 8-foot would do the job just as well as 10-foot. The only thing that's unique is where the sidewalk was placed already on the property. Am I missing something?
Yeah, I think we'd want to, it's my look at the aerial photo, it appeared that the sidewalk was already there and they built the porch so the entrance lined up with the sidewalk. I don't believe the sidewalk is new. I believe the sidewalk was already existing in that location. So I think that is a fair statement that the need for the 10 feet was so it would line up with an existing sidewalk. I've also confirmed with the building official that HDN Remodeling is a registered craftsman, so they follow in the registration category, not the licensed contractor category.
So under the registered category, should they have known that there should have been a building permit pulled?
Well, a registered contractor generally either works as a sub doing small work under a general contractor's license, or they're doing things like fences or things like that. So a registered craftsman, it's a judgment call for you whether you think they should have known. Registered craftsmen don't necessarily have experience pulling building permits because the city generally issues building permits to licensed contractors, or as a homeowner, you can, as a homeowner, apply for a building permit to build a covered front porch and you can build it yourself on your own property and hire people to help you if you as the property owner are the general contractor. But you as the property owner are still responsible to obtain a building permit. And so all I can say is that I've done some projects on my own home and the contractor has said, well, you as the owner are responsible for getting the permits. So I, as the owner, applied for the permits and the contractor did the work. But I'm sure each arrangement is different, but the only parties that can obtain a building permit are a licensed contractor or the homeowner themselves can declare themselves to be the general contractor if it's on their own property.
Okay.
One thing I think you guys should consider, since there are two handicapped residents in this, you know, the 10-foot might be unique in the sense that both of them could be coming out of that front door at the same time. And, you know, they need 5 feet generally for wheelchair access. 8 foot would not be sufficient if both of them were coming out at the same time. So if you needed a unique factor to this, I could see that being something that me being a contractor in the city would ask for.
Any other questions or comments from board? I guess mine would still go back into, part of it becomes an issue for me on this part of it was going to be back to the footing. So if, Jerry, if you were going to go out and do the inspection right now, does it pass inspection?
Well, no, it wouldn't if it's only 32 inches. So they'd have to correct that.
Okay, so at that point, they would have to unload it, re-pour it.
Yeah, they can dig underneath. They can temporarily shore it up and add footings underneath. I'm not sure if they put the posts in the ground or if they're sitting on top of the footing, but either way, they could repair that.
Okay. So we would move now to, and I know that we had, if there's no other questions for applicants or the staff, so I know that we had letters from the neighbors. Are there any citizens, Dustin, on the Zoom meeting?
I'm not seeing anybody additional to the meeting at this point, other than the applicant, staff, and the board.
Okay. So if we don't see anything, then I'm going to close the interested citizens portion of the meeting and direct it back to the board for discussion and action. So discussion among the board, thoughts?
No, it being after the fact, obviously is a bad look. I could understand why he wouldn't know that though. Not that that gives him an excuse. But I feel like if it would meet, if they could get it to meet the requirements and it's going to match the house, I just feel like it would become more of a hardship to take it down at this point. That's kind of how I feel on it.
This is Dortzweiler. My comment on the matter is I don't see anything that's necessarily unique about the property that would require a variance. I'm not sure that our scope is necessarily whether or not a permit was pulled or not to approve something. I think we need to be looking at the uniqueness of the property. That's just my thoughts.
Okay. Any other comments? I guess, I mean, and again, for me, it's coming back to, again, we have another situation of somebody after the fact found out that they should have had a permit. They didn't have a permit. I can understand building it out to 10 feet to line it up with the existing sidewalk part of it. I don't agree that you need the 10-foot because of the handicap part of it. I mean, you're still not going to have two people coming out of the door at the exact same time. With 8 foot, you could still have somebody come out, have them position a wheelchair, go down with a ramp. I mean, the stairs obviously aren't going to be a benefit to the handicap. So the 8-foot part of it is all that's required. I think the only reason it was out 10 feet was strictly to line it up with the sidewalks. Don't think that that makes it unique at all, because if they were truly trying to do it, they could have still had it go to the sidewalk some way. So I guess it's back to a question of, does the 2 extra feet make a huge difference at this point? I think part of it is you have enough of the neighbors that don't disagree with it. So I guess I would be in favor of allowing the variance, provided that everything is up to code and meet the inspection process.
Yeah, I agree, John. I'll go ahead and make a motion that we approve application V21-1 with the stipulations that it meets building code and is matching with the house and paint and material.
Okay.
I would second that.
Okay. So we have a motion and a second. Can we have a roll call on the vote?
Good. Motion by Sharp, second by Miles to approve the requested setback variance, provided that the porch is determined to meet building code requirements and is painted to match the house. All in favor of that motion, Mr. Rada,
Aye.
Mr. Dorsweiler,
Aye.
Mr. Olson,
Aye.
Board Member Miles,
Aye.
Board Member Sharp.
Aye.
Okay, so that motion passes by a 5-0 vote by our record. And so again, just to clarify, the building permit for this porch is still sitting down here, not issued. What your action today does is allows us to issue the permit and then put those stipulations that you had on the permit, which would require issuing the permit and then follow-up inspections. So we appreciate the time with that. Mr. Wilson, would you want to be copied in on the correspondence that relates to this case, just so you are informed and have a record of what happened?
Yes, I think that would be helpful, just to make sure that Sergio can get this structure up to code. And
so what we do is prepare a written record of today's action, and we'll make sure that you're copied in so you can assist as needed.
All right. Thank you. So that completes current business. Is there any unfinished or other business?
Well, we have submitted your annual report from last year to the City Commission on your behalf. We will have a board meeting on the 18th of March. We have an application filed for that meeting. I think that may or may not be USD 305 spring break. And if there's any travel plans or things that you might have for that week, and that might put us in risk of not having a quorum of 4, anything that you can do to provide us that notice ahead of time would be helpful. But we do have an application filed for March, and we are looking at working with an application. It'll probably get filed for April. The other thing, it hasn't come out yet, but it's been Staff's been informed that the county health officer is going to issue a new health order that would up the size of gatherings from 15 to 50. And if that is the case, it's possible that we will transition back to having live in-person meetings, because it's very seldom that we're going to have over 50 people at a Board of Zoning Appeals meeting. So we will keep you informed. So what we say is we'll be Zooming for the foreseeable future, but if there is a change to in-person meetings, then we will let you know.
Okay, thank you. I think these have gone well.
Yeah, I have to say that the Board of Zoning Appeals has probably set the bar for all the other boards in terms of not having technical glitches and having the people, the applicants and the representatives being able to participate. We've worked really hard on that, so to make sure the applicants know how important it is for them to be represented somehow and giving them help to get connected. So we think it has gone well. We're not positive that we're going to switch back to in-person meetings, but we're just giving you a heads up.
Okay, thank you. So public forum. So Dustin, is there anybody on?
We do not have any outside parties in the meeting currently.
Okay, so we're going to close the public forum section of the meeting and move to adjournment.
I move that we adjourn the meeting. This is Dortzweiler.
I'll second that. Sharp.
Okay.
We have a motion to adjourn. Those in favor, Board Member Miles,
Aye.
Rada,
Aye.
Olson,
Aye.
Dorsweiler,
Aye.
Sharp.
Aye.
Okay, we are adjourned, and we will keep you informed as to how the next meeting will take place.
Thanks, everybody.